extraordinary amount of misinformation, distortion, and disinformation is being spread about a very simple interim order passed by the Supreme Court in its last hearing on the SIR Bihar issue on 10th of July 2025. I will therefore deal with the attempt to distort it and tell you first and foremost what was our rationale, what was our principal conceptual argument, only to put the argument, not its merits. It may be rejected against me, it may be allowed in my favor, that is for the court to decide. I am only giving you a summary, synoptic, thumbnail sketch about the various points we are raising. Second, we are telling you about the distortions and the misinformation, as I said. And thirdly, and more importantly, we are also making it clear that the submissions and the arguments were on two levels. Per se, lack of jurisdiction and law and authority. And secondly, the operational reality, the logistics, how you can do it. The misuse of power, assuming you have power, although we say you have no power at all in law. Before I tell you also the synoptic summary, let me add that I had the privilege of representing 10 parties in 3 petitions. One petition comprised a holistic collective petition by 8 political parties, and therefore the India Alliance also has a great interim victory as far as the interim order is concerned. That comprised the Congress Party, the CPM, the CPI, the CPI-ML, the SAPA SP, the DMK, and the Sena, Shiva Sena, Uddhav Thackeray. I also had the privilege of representing Ms. Mahua Mitra from the TMC in a separate petition and also PUCL in a third petition. What were the broad contours of that which we raised before the court? One, it is for the first time that you have created an artificial, non-existent, doubtful, hanging in the air category, like a Trishanku, neither here nor there in suspended animation. That category is this. Anybody and everybody who is registered after 2003, which is estimated to be above 4.9 crores, maybe 5 crores, maybe 4.5 crores, doesn't matter. All of those people are deemed to be in a suspended category where until they prove, and the proof is focused on citizenship, despite being a voter on a registered voter list for the last 10, 15, 20 years, they may be barred from voting. The obvious implication is an unprecedented implication. One, the burden of proof is reversed. The EC is not coming forward and saying so-and-so person, this journalist is born in Bangladesh, he is a non-citizen, I have material. Give him a notice, adjudication happens. He has to prove that he is not so-and-so. Secondly, this is done by recourse to an artificial further subcategorization in this category of all those who were registered after 2003. Remember, we are talking of already registered voters. Already registered voters after 2003, category A, born or concerned between this year and this year, they give a year, I'm not going to detail, 87 to some years, have to produce their birth certificate. If you are on 2003 list, you are left out. If you are not 2000 list, then you must produce so-and-so birth certificate of your own. If you are in another time period, you must have your own birth certificate and that of your father or your mother. If you are in the third time period, you must have the birth certificate of yourself plus your father plus your mother. You can imagine how many of you, if asked within 1 week or 2 weeks or 4 weeks in Delhi to produce a birth certificate, produce it. I doubt many of you can. Certainly I could not. If given not sufficient notice, here I have to get my father or mother and then my father and mother in some cases. The other aspect we raised was that the focus of this exercise was itself unconstitutional. This exercise was focused on determining nationality, citizenship. That is totally beyond the jurisdictional remit of the Election Commission. The Election Commission cannot decide citizenship. Citizenship can be decided either by foreigners' tribunals or by Government of India under a different act, Citizenship Act. in the course of dealing with already registered voters, you cannot disenfranchise them by saying that you're not a citizen. This exercise has to be done somewhere else, and then you can come and say, I have proved that this man is not a citizen, therefore remove him from the list. You can't tell that an already registered voter is subjected to a scrutiny by the Election Commission and removed on the ground of citizenship. Number 3, there is a more than 20-year-old judgment on this by the Supreme Court called Lal Babu Hussain, which has held exactly this, that citizenship is not within the domain of the Chunav Ayog, the Election Commission. It is also said that there is a fundamental difference between those who apply for registration as a voter, those who want to come into the list of registration of voter for the first time, versus those who are already sitting on the register. And therefore, this is a without jurisdiction, without law exercise at the base, in a conceptual fundamental sense. We then also pointed out the fourth aspect, that this involved roughly 4.9 crore voters who in the original design had to be decided this way or that way in 1 month, expiring on 25th of July. Now they are saying that all of them can apply, but we'll decide them within 2 months later. So the same principle cannot be possibly by any logistical exercise, by any amount of an army doing it, do it in 2 months or 3 months. How you will get citizenship proof in this time is impossible to conceive. Next is a very, very important point on which the court gave us a very, very preliminary interim order. The document itself lists, the Election Commission document order lists several documents, but makes it clear that none of them will decide the matter unless you produce your citizenship proof. It is written there, optional.